Hello and welcome to BYJU'S Exam Prep IAS. Welcome to the big news. The topic for today's discussion: Supreme Court upholds EWS quota. Before we understand what this topic is in greater detail, we have two important announcements. The first is in reference to PTS 2023. BYJU'S Exam Prep IAS recently conducted the first mock test. Most of you would have given this mock test. You would be waiting for your ranking as well, and you would also want to know how to approach a question, how to make use of the elimination process, and to give you an entire perspective about this first mock test. What we will have is a full length paper discussion today at 5 p.m. This will be live on our YouTube channel. You can also watch it on our BYJU'S Exam Prep application. So don't miss out. Watch this full length paper discussion by all faculty members of BYJU'S for all subjects live on YouTube at 5 p.m. The second announcement is in reference to the Telegram channel. If you have not yet joined the Telegram channel, please do join so that you get all the current affairs related updates. Let's get started and try and understand what is this topic all about. First, we have to understand the meaning of reservation. What is the reservation? Reservation is also called by affirmative action. Reservation can also be seen as positive discrimination as well. What is reservation in simple terms? Let's say, for example, there are about 100 seats in the government jobs. Out of this 100, about 22.5% will be reserved for the SC and the ST, about 27% will be reserved for the OBC, and rest of it will be open for the general category. So what does this mean? This means out of 100, about 15 seats are only meant for the SC community, about 7.5% is only meant for the ST community, and about 27% or 27 seats out of 100 is only for the OBC. So a person from the general category cannot lay claim to this 15% or the 7.5% or the 27%, but he can look for and fight in an open competition only for about 50 seats. So reservation basically is about reserving access to the seats in the government jobs, educational institutions, and even legislature to certain sections of the population. Why do we have this whole idea of affirmative action or reservation? That is because these section of the people may in the past may have been inflicted with large case injustice, or for us to overcome this injustice that they have suffered in the past, we have to empower them. So in order to empower them and to make sure that we compensate for the past or the previous injustice, they have been provided what is called as the reservation. This is also called as the positive discrimination. This is also called as the affirmative action. So how is it divided? Reservation in India is provided to scheduled castes, scheduled tribes, and other backward classes at the rate of 15%, 7.5%, and 27% respectively in case of direct recruitment and all India basis by competitive examination. Now, what is the basis for this reservation? What we have to look at is the Constitution of India. We have three important articles. One is the Article 14, second happens to be Article 15, third happens to be Article 16. When we speak about Article 14, it says equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. When you look into the first part, it basically is asking the state to prevent discrimination in all its forms. So the first part is negative in concept. The second part is positive in nature, which basically is asking for the special treatment. So special treatment basically means treat the likes alike, and at the same time, if you have an intelligible differentia where you can categorize them because there have been grave injustice in the past, also you can segregate them and make sure that the likes are treated alike. So this basically means that you can also bring in the concept of positive discrimination under Article 14. Then we have Article 15. It goes on to say prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth. It is only these on the basis of which the government will not be able to discriminate. But for the rest of the other criterion, it will be able to differentiate. It will also be able to discriminate as well. But only for these criterion that have been established, the religion, race, caste, sex or place of birth, the government, the state cannot discriminate, says Article 15. Article 15 further goes on to say, nothing in this article shall prevent the state from making any special provision for the women and children. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of socially and educationally backward class of citizens or for the scheduled castes and the scheduled tribes. This basically means that we have in Article 15, which gives this very idea of reservation for a certain section of the people in the country. Then we have Article 16, which speaks about equality of opportunity in matters of public employment. Look at clause 3. It says, nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local or other authority within a state or union territory, any requirement as to residence within the state or union territory, and at the same time, nothing in this article shall prevent the state from making any provision for the reservation of appointments in favor of the backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. These three articles clearly point out that in case of public employment, in case of educationally backward classes, they would be able to provide reservation to a certain section of the society. Now what we have to look at is the politics of the country. Let me take you back to the year 1979. What exactly happened in 1979? We had the Janata Dal government. This was headed by Prime Minister Morarji Desai. Prime Minister Morarji Desai's government appointed one of the commissions. This commission was called as the Second Backwards Class Commission. It is also called as the Mandal Commission. So the Mandal Commission looked into the backward classes. What did the Mandal Commission say? The Mandal Commission looked into the entire north, south, east, west of the country, and it ultimately said that we already have some reservation for the SC/ST. So for the SCs, there was reservation of about 15%. For the STs, what we have is a reservation of about 7.5%. In addition to the SCs and the STs, there are other backward classes, which means there are many other castes which also needs to be empowered as well. So we already had reservation of about 22.5%. In addition to the SC/SC, what we can come up with is called as the other backward classes, and they have to be provided with the reservation of 27%, said the Mandal Commission. So the Mandal Commission gave its report in 1980. By the time this particular report was to be implemented, the Janata Dal government was out of power. Then comes the Congress government. The Congress government was not active in itself. It did not want to implement this Mandal Commission. Then what we have is the VP Singh led Janata Dal government that immediately comes to the power in the year 1989. And when it came to the power, it immediately issued an office memoranda, and ultimately it said that it will be implementing the Mandal Commission. So what is this all about? Basically, up until 1989, we had reservation for the SC as well as the STs. About 22.5% reservation was given to the SC and the ST community. In addition to this particular reservation, another 27% would be accorded to the OPCs, said the VP Singh government. As a result, there was a lot of chaos in the country. Many people opposed it as well. Many people even passed away fighting against this discrimination that was happening according to them. And ultimately, what we have is this particular case goes to the Supreme Court of India. So even before it goes to the Supreme Court of India, PV Narasimha Rao led Congress government further gave 10% reservation grant to the economically challenged sections of the country. So there was lot of hue and and cry, there was allegations that this is discrimination, so it had to be sorted out. So then finally what we have is one of the landmark judgments delivered by the Supreme Court of India in Indra Savni versus the Union of India and others. There were number of cases that were filed in multiple high courts. There were number of writ petitions that were filed in number of high courts. So the Supreme Court made sure that all these writ petitions were taken away from the high court, and it delivered the landmark judgment in terms of the reservation, whether this Mandal Commission report had to be implemented or not. So what we have is the Supreme Court looking into this very provision, that whether OBC reservation has to be given, whether reservation has to be pushed to about 50%, was what was Supreme Court looking into it. There were arguments made by the respondents as well as by the petitioners. What did the petitioners say? The petitioners went on to say that this whole idea of reservation system on the basis of caste system is further increasing the evil caste system in the society. It is dividing the society in terms of the forward class as well as the backward class, and ultimately it is breaking the society. So this whole idea of caste system based reservation that we are according to the OBCs or that is already present should be completely eliminated, as this is brewing hatred within the communities. So this had to be eliminated, said the petitioners. Then we also had the respondents as well. The respondents went on to say that there are some backward classes in the society. These backward classes society are not economically empowered, they are not caste wise empowered, sociologically in society they're not given that respect as well. So in order to empower them economically and socially, what we have to provide is reservation, so that over a period of time they have an economic advantage as well, they are able to empower themselves. So there were certain arguments put forward by the petitioners, there were certain arguments put forward by the respondents, and ultimately we have the Supreme Court of India deliver a landmark judgment in the Indra Savni case. What did the Supreme Court say? Supreme Court in this Indra Savni versus the Union of India upheld this particular argument that reservation should be given to the OBC. So what did it say? That SC/STs are already provided with reservation of up to 22.5%. In addition to it, the reservation for the OBCs can be given, said the Supreme Court of India. So the Supreme Court of India said that backward classes under Article 16 of 4 cannot be identified on the basis of economic criterion, but the caste system also needs to be considered. The concept of creamy layer was laid down, and it was directed that such a creamy layer be excluded while identifying backward classes. So within the OBCs, it divided what is called as the creamy layer and non-creamy layer. Only the non-creamy layer were entitled to reservation under the OBCs. So the creamy layer, which means they are already economically advanced, or their parents are holding some of the constitutional positions, they are into group A or group B services, they are already empowered. Such people are called as the creamy layer. They would not be entitled to the reservation, but the non-creamy layer under the OBC are entitled to the reservation, said the Supreme Court of India. Article 16 of 4 does allow the classification of backward classes into backward and more backward. Reservation shall not exceed 50%. Moreover, reservation in promotions shall not be allowed. Any new disputes regarding the criteria were to be raised in the Supreme Court only. The point that the Supreme Court made in this particular judgment was also about 50% criterion. This basically meant that whenever reservation is to be provided, it should not breach this 50% mark, said the Supreme Court of India. Now what we have is the Government of India come up with the 103rd Constitutional Amendment. What is this 103rd Constitutional Amendment? So it basically introduced, we had up till this amendment Article 15 of 5, but it introduced Article 15 of 6. It also introduced Article 16 of 6 as well. What was this basically about? This was basically about increasing the reservation for the general category. What do you understand by this? We already had reservation for the SC community. We already had reservation for the ST community. We already had reservation for the OBC category. This was less than 50%. But what did the central government do? The central government provided about 10% reservation to the economically weaker sections among the general category. So this meant that it was breaching the 50%, and at the same time it was also giving the reservation not on the basis of community, not on the basis of injustice that has committed in the past, but this is on the basis of economic criterion. Up until this amendment, it was only the social injustice, educationally backward, who are provided the reservation. But with this 103rd constitutional amendment, the government introduced economic criterion. So in addition to the existing reservation, which is about 49 to 50%, what we have is 10% reservation that was to be given to the economically weaker sections only among the general category. So if there are SCs or STs or OBCs who might also be economically backward, they were not provided this 10% quota. So this was introduced in Article 15 of 6 as well as 16 of 6. How do you identify this 10% category? So these are the economically weaker sections in the general category. They do not belong to the SC community, they do not belong to the ST community, they do not belong to the OBC community as well. What was the criterion drawn by the Government of India? Persons who are not covered under the scheme of reservation for SCs, STs and OBCs and whose family has gross annual income below rupees 8 lakhs. So their gross income should be less than 8 lakhs. Also, persons whose family owns or possesses any of the following assets shall be excluded. That if they have 5 acres of agricultural land and above, residential area of 1000 square feet and above, residential plot of 100 square yards and above in notified municipalities, residential plot of 200 square yards and above in areas other than the notified municipalities, the property held by the family in different locations or different places and cities would all be clubbed together while applying the land or property holding the test of the EWS status. So if they have to take this EWS reservation, they should be following this eligibility criterion. If they fall within it, they would be given the reservation. If they do not fall, they would not be given the reservation under the EWS category. So people were not happy with it. Why? Because it was again breaching the 50% mark as Supreme Court had given in the Indra Savni case, and they were also not happy that when you are giving reservation for the 10%, it did not include within it the SC, ST and the OBCs. So ultimately it goes to the Supreme Court of India. So the Supreme Court of India was to check whether this 103rd constitutional amendment brought in by the Government of India, is it right or wrong? Is it constitutionally viable? And now the Supreme Court has now declared its judgment, and it has said and it has upheld this constitutional amendment. So the 3 questions that was asked before the Supreme Court of India was, earlier we had what is called as the community that was taken into picture. Now individual is taken into the picture on the basis of economic criterion. So can economic criterion be provided for this new category as the affirmative action? Earlier it was on the basis of sociological, it was on the basis of educational backwardness, but now what we have is the economic criterion. Is it right? Is the first question that was asked to the Supreme Court of India. The second was the scheduled castes and scheduled tribes and non-creamy layer, other backward classes were excluded from the newly inserted clauses of Article 15 of 4 and 16 of 4. Is it right? And the ceiling of 50% reservation was breached and the individual rather than group became the basis of backwardness. Is it right? So the Supreme Court has answered all these questions. So we have the judgment passed by the Supreme Court of India in the 3:2 majority, and the 3 judges have upheld the 103rd constitutional amendment. Let's break them into compartments. So the first is in reference to the economic criterion. So the government came up with an economic criterion. It said that 8 lakhs and below people, are they eligible to the reservation? Yes, said the government. Can the government bring in this economic criterion, and is it constitutionally right? So the majority have said yes, it is constitutionally right. What did the majority say? The majority judgment went on to say that affirmative action is basically about bringing empowerment to certain section of the people. So in the past, we have made sure that we have taken the sociological picture, we have taken the community as one of the affirmative action plans. So that is why SCSTs were provided reservation, OBCs were provided reservation. Now, in an extension to the affirmative action, they can also bring in the economic criterion. So it said that we already have affirmative action on the basis of educationally backward, on the basis of social backwardness. Why not extend this? Extend it and bring the economic criterion into picture as well. So to this meaning of affirmative action, it has also extended the economic criterion. Until now, we looked at social backwardness, we looked at educational backwardness. Let's add the economic criterion, and this is right, said the majority judgment. So the majority judgment also went on to emphasize about preamble as well. When we speak about preamble, we have the justice that it speaks about. What are the justice? One, it speaks about social justice. Second, it speaks about political justice. Third, it speaks about economic justice. Since these people will also have to be provided the economic justice, why not bring in this economic criterion? So they went on to observe that for the furtherance of the preamble's goal of achieving justice on the social terms, what we have is reservation in the form of SC/ST reservation, OBC reservation, which is sociologically correct. But for the economic justice, these people are economically poor. So let's extend this affirmative action. So the first point is answered saying that this is the right criteria. The second question was the scheduled caste, scheduled tribes and non-creamy layer other backward classes were excluded. What do we understand by this? We have 10% reservation given by the government of India. This 10% is only for the general category, which means the SC/ST cannot lay claim to this 10%. The OBCs cannot lay claim to this 10%. This 10% is only for the general category, and they should also meet the economic criteria set by the government. So there was a question, why not include the SC/ST as well, OBC as well into this 10% criteria? So the Supreme Court looked into it, and the majority said that if existing beneficiaries are not excluded, then it would be double advantage, benefit and all advantages will already go to the existing communities. If SC/STs, OBCs are not eliminated from this particular bracket, they are already getting the reservation. If they also become part of this as well, they will get double advantage. So those from the general category may be eliminated, and those who are entitled to it may not get it, because there will be double competition, and these people will also get excessive benefit and advantage. This is the viewpoint of the majority judges, but the minority dissenting judges also had a valid argument as well. They went on to say, when you look at data which the government itself has said, most of the people who are from the economically backward sections are the people from the SC/ST community and OBCs. So if you are eliminating such people, these people may not be empowered. That happens to be the dissenting viewpoint of the minority judges. And the final question was whether this 103rd constitutional amendment violating Indira Savni judgment or the 50% reservation. The Supreme Court went on to say that Indira Savni judgment in 1992 was not inflexible. It did allow certain breach in certain extent as well, and at the same time it applied only to the SC, ST and the OBC community and not to the general category. In fact, they also referred to N.M. Thomas case of 1976, Vasant Kumar case of 1985, and further went on to say, for a court to say that reservation should not exceed 40%, 50% or 60% would be arbitrary, and the Constitution does not permit us to be arbitrary, were some of the statements given by the Supreme Court judges in the past. The same was taken into picture. However, the dissenting voice, that is the minority voice, also went on to say that if we are breaching this 50%, what we will have is more compartmentalization, and this can also open up Pandora's box as well, and this can lead to further gateway for further infractions, as more breaches can happen in the near future. So these were the questions that was asked before the Supreme Court of India, and all these questions were answered by the Supreme Court of India. How exactly did this case proceed? Jan 8 2019, Lok Sabha clears the 103rd constitutional amendment bill. Jan 9th, Rajya Sabha also clears the bill. Jan 12th, Ministry of Law and Justice issues notice saying President Ramnath Kovind has given assent. February, it was challenged in Supreme Court. Supreme Court issues notice to government on pleas challenging amendment. Declines to stay the 10% EWS quota. September 8, 2022, bench constituted to hear appeals. September 13th, Supreme Court starts hearing arguments. September 27th, Supreme Court reserves the order. And on November 7th, Supreme Court by majority of 3:2 upholds validity of 103rd constitutional amendment providing 10% quota to EWS in admissions government jobs. This is it for today. Thank you for watching. All the best.